Thank you very much, Honorable Shakeel Mohamed.
Thank you, Mr. Deputy Speaker, sir. I will dive right in this piece of legislation, with your permission. I will address you, Mr. Deputy Speaker, sir, and the House on specific clauses of this particular bill. I will address the House on Clause 8. I will also address the House on Clause 16 and on Clause 23. I will start with Clause 23 because this is precisely what the Honourable Minister preceding me spoke of a few seconds ago. I agree with the Honourable Minister who presented this legislation that at least 7 of the offences that existed in the previous bill of 2003, in the Act of 2003, is reproduced to a certain extent in this piece of legislation that is being proposed, but it is updated in order to conform with the Budapest Convention. This is as far as I will agree with him. And let me forthwith explain why and where I disagree with him. The previous legislation, or the legislation that this bill seeks to repeal, did not contain any section pertaining to the failure to moderate undesirable content. What people would like to understand today is what exactly are we all harping about? Why are we not agreeable with one another? And I think it is necessary, therefore, to try to be very practical in our approach. Let us try to understand what Clause 23 means. Clause 23, in very layman's language, means as follows, is that I, for instance, understand it to mean the following. The Honourable Minister has an online account. The Honourable Minister has a Facebook page, which he very regularly updates. And I've seen it. He smiles very often in his photographs, and he looks good in his photographs. I see some of the posts, how he has posted.
Look at me.
I mean, he's got a nice smile. I can look at him as well. But obviously, I'm addressing you.
Raji, you look at me now.
Don't worry about it. He doesn't fear me. And when he posts on his page, and whenever he puts photographs on his page, whenever he puts photographs of going, for example, to celebrate recently the centenary of certain citizen, I've seen it. Because we're friends. So it comes on my page. So don't fear that I said we're friends. Your friends won't mind. But we are friends on Facebook. And when he posted that, there were many comments that were quite rude as regards the minister. They were rude against the minister because they said to him in those comments, why is it that during the COVID danger, you're out there without distanciation sociale doing something like that? He put up another post with regards to an inauguration of a road. That is his duty as a member of that constituency. But he also had good comments, but some were bad comments. That happens. But some of those comments criticize government for their incompetence. Some of the comments criticize the fact that certain ministers organized those events in spite of the fact that there was the COVID danger. The Minister of Social Security should not have organized such an event. This is what the comment was. It also said that the Minister of Public Infrastructure should not have organized inaugurations. That was the comment. They called those ministers incompetent. Some people, therefore, would say, this is a true comment, an opinion, which is protected by the liberty to have one's opinion under our Constitution. But what this government is telling us today in this legislation is that if anyone posts a comment criticizing one minister as being incompetent or any other derogatory remark as far as his policy decisions is concerned, that comment could be qualified to be deceptive or inaccurate. In other words, they may not agree that they are incompetent. Obviously, they would never. They would say this is deceptive language because you're saying I'm incompetent. And therefore, if my page or your page or anyone else's page bears a comment of that nature that criticizes government for what they're doing or any particular minister, it could therefore tantamount to fall under section 23(3)(a), which is, for the purposes of this section, I read, undesirable content includes any online content that is deceptive. So the comment calling Honorable Balgobin incompetent would be deceptive, as far as he's concerned. It could be inaccurate, as far as his friends are concerned. But it could be totally accurate, as far as others are concerned. So what does that mean? It would mean that that person would be liable to being reported to the police for not monitoring the comments on the online account that contains comments that are deceptive or inaccurate vis-à-vis him, and it would open him to being arrested. It would open him to be liable to conviction to a fine not exceeding 1 million rupees and to penal servitude for a term not exceeding 20 years. All this started with a simple event organized in a constituency and someone not appreciating the competence of a minister. That's how practical one has to be to understand how far this legislation can go to hurt. I am not saying that the intention of the minister is to hurt. I am not saying that the Honorable Minister Balgobin wants to hurt anyone. I am saying that the legislation that he is proposing has the potential of hurting. And I would like to believe that he was not even aware of that possibility. Because I do not want to have any procès d'intention against the Honorable Member, the Honorable Minister. Maybe he did not realize that this could be taken as far as that. And is this what we want in a democratic society under the garb of supposedly protecting our children? Is this what we're going to teach our children? That you have to ensure that your Facebook account does not contain anything inaccurate. For instance, do not ever say that a company is, for instance, fleecing its clients because its customer service is lamentable or that it is selling damaged goods to people. That would be inaccurate according to the company. And that person who posts something like that and who does not ensure that this post on his page is not monitored or deleted could be reported to the police simply because it is a customer who is not satisfied. The minister's intention is not that. I take it. But the possibility of it going that far is not a stretch of imagination, but real. Second issue I'd like to deal with your permission, sir, is the misuse of fake profile. We've heard our friends talk about the misuse of fake profile. I have myself, and I invite the Honourable Minister presenting this bill and the Prime Minister to visit the Cybercrime Division at the CID. Go to the Central CID, go down that long corridor in this old building falling to bits and pieces. Walk that corridor, hear the wood creaking under your feet, and walk to the last office, that is the Cybercrime Division. Open the door and see the sad conditions in which those police officers are made to work in. I'm not saying it is the fault of this government. I'm saying this is the condition in which they are working. I'm saying that since this government is in power, it is your responsibility to look into it. Go there. Go and see what it's like. Go and see how the desks they work on are so full of paper. Go and see the type of computers they have that belong to the last decade. Go and see the tools that they have to work that are not even modern. You expect to have beautiful speeches about Mauritius having to be a modern state, about how you are going to comply with this convention and that convention, when we are not even able to give police officers proper tools in order to investigate? Can you imagine? They don't have proper computers that are quick enough in order to operate. They don't even have access to internet within that office. I have been there, Minister. Honorable Minister should know I go there. Not only have I been there, also to make complaints against some ministers of this former government. At the time, they were not ministers. They were simply backbenchers. It took 5 years. You want to know how things work? It took 5 years for me to even harass the police almost every other month to get an answer as to what had happened following my complaint. Not even by the use of a fake profile. Honorable Minister Tilak should hear. There are ministers in this government who have in the past, recent past, made use of their own profile to defame, insult. They were reported and harassed the police was. Why is it that nothing is happening to that person? Why is it that it's members of the opposition, they are arrested? Why is it when it's members who are against government, early in the morning, the police visits their home and arrests them? Why is it when it comes to a member of government, 5 years on or more, nothing has happened? Answer me. My phone calls never stopped. And finally I found out that this person who is today a minister was warned by the DPP. So, yes, I agree with what Honorable Tilak has said. I agree with what the Honorable Minister has said, that he is totally right, and it is indeed a sign of hope when I hear a minister on the other side say it, and I am of the view that here are not many people like him. There are not many people like the Honorable Minister Tilak, because he said it with such sincerity. I commend him. If only the sincerity that he has displayed, he could share it with some of his colleagues who have rendered themselves guilty of what he abhors. So why, therefore, if a fake profile is so wrong, why make it legal for it to be used? Because what the Honourable Minister is saying, if you have a fake profile, it is fine, as long as you don't misuse it. What the Minister is saying is that il n'y a pas de problème si vous avez un faux profil. Il est tout à fait acceptable, voire légal, d'utiliser ce faux profil. Mais je vous décourage to use it in a bad way. Why so timid? Why not make it unlawful to have a fake profile? Why not make it unlawful to you have a fake profile? Going onto the net, having an online account which is false in itself should be made an offense. That is how you take le taureau par les cornes and you ensure that there is no abuse online by any person. This is what I recommend the minister to do. The third thing I'd like to speak of here is Clause 8. Clause 8 talks about the unauthorized interception of computer service. And I have done some research to understand Clause 8. And Clause 8 existed in the previous law. And it was dealt with by Section 5 in the actual law, which will be repealed soon. The difference between Clause 8 in the bill today and the previous law, the actual law which will be repealed soon, is that there is a waiver in there. It says that unauthorized interception of computer service, and interception here also includes phone tapping. That's what I'm getting at. Interception includes phone tapping. What this legislation does, and repeats what was said in the 2003 law, is that it shall be unlawful to tap. But the difference with the actual law is what the minister proposes, is that a person shall not be liable for unauthorized interception. A person shall not be liable for interception without authorization if he is acting in the performance of his lawful duties contractual obligations and is discharging a legal obligation. What does that mean? So if someone is acting in the performance of his lawful duties, he can intercept telecommunications, data unlawfully. If he is performing his contractual obligations, he can do so unlawfully. If he is acting, discharging a legal obligation, he can do so unlawfully. I found that quite interesting. Because when one must not only read the convention, one must also, Mr. Deputy Speaker, sir, read the explanatory report to the convention. Not only the convention. There is an explanatory report to the Budapest Convention of the 23rd of November 2001. And that particular explanatory report talks about precisely Article 3 that is taken here in Clause 8, interception. It says here that interception includes phone tapping, intercepting data, intercepting WhatsApp, intercepting telecommunications by internet. And what is interesting here is that the explanatory report makes it unlawful for any person to go and intercept any communication unless he has a judge's order, unless it is for some criminal investigation. This is what the Honourable Minister said, that it is only s'il y a une affaire qui a été rapportée à la police, si la police doit enquêter, si une instance doit enquêter, il doit y avoir une demande devant le juge en chambre pour obtenir la permission d'intercepter. C'est ce que le ministre a dit. Faux. Ce que le ministre n'a pas dit, c'est ça qui est important. Ce que le ministre a refusé de dire, c'est ça qui est important. Ce que le ministre ne nous dit pas, c'est que he goes against the convention by having added that last paragraph. When he says he's acting in the performance of his lawful duties, contractual obligations, or is discharging any legal obligation, as a waiver of liability, cela n'existe pas dans la Convention. Cela est importé par le gouvernement du jour. Et my investigation went further. When you look at the licenses given by the ICTA, the ICTA, let me look at one here, given to MTEL, and another one given to Mauritius Telecom. They are the same. Internet service license. They are given under certain conditions. And all those licenses, I invite the members of the public to go on the ICTA web page and to look at all the licenses that have been issued and look at clause 21 of those licenses. Clause 21 reads, the authority reserves the right to exercise such monitoring of the services as may be required for national security. Up to now, j'ai pas un problème. National security, you need to monitor, fair enough. But what is shocking in the license is that the title is Exceptional Monitoring for State Security, but here it says in the public interest. Therefore, it is contractually lawful for the ICTA to reserve the right to exercise monitoring of the services as may be required for national security or in the public interest. And the licensee shall in such a case make available to the authority all monitoring facilities at his own cost. So, in the licenses, the government, and not only this government, I say it again, governments who have given those licenses that are exactly the same as this one, even the previous regime, have facilitated the monitoring of telecommunications and data and internet for the purposes of not only national security, but also public interest. That is not defined. Public interest for Honorable Jagnat could be a different thing as opposed to Honorable Rangulam. So therefore, it is my contention in conclusion that this last paragraph added by the minister goes against the convention and opens the door to legitimize phone tapping and communication interception. And it creates a waiver of liability, creating a situation where today you can intercept, you can monitor, you can go behind the back of the judging chambers, because for judging chambers it talks about criminal issues, investigations. Here it talks in the license, public interest. A simple phone call from le nominé politique du Premier ministre du jour. The license obliges the service provider to give monitoring. So what I say is the following. This government and any government cannot and should not berner la population, to make the population believe that it is only when you go to judging chambers that you intercept and monitor communications. Communications are intercepted and monitored contractually as we speak, in public interest, whatever that means. And this is something that must be something of the past. It is not an excuse to come and say it was the case like that when you were in government. It is not an excuse to come and say when you were in government it existed. That would be the excuse du faible. Either you are better or you're the same. Because right now, you're verging on worse. Those are my comments. Thank you.
Thank you very much. I'll suspend for 10 minutes. I'll be right back.